Welcome back. Many of our viewers from last week's video on the draft withdrawal package got in touch to say, do please produce a talk specifically on the citizens' rights provisions. So here we are. Now it's important at the outset to clarify exactly which provisions we're going to discuss and why. And there are three quick points here. First of all, we're talking about the legal regime that will govern the future protection of citizens from the UK and the EU27 who've already exercised their free movement rights by the cut-off date which is provided for under the proposed withdrawal treaty. We're not talking about UK or EU immigration regimes that will cover everybody else into the future. Now on that point, suffice to say that Theresa May is now fond of boasting that free movement is coming to an end once and for all, and indeed it does seem to be one of the few significant things that she believes she's achieved in these negotiations. Certainly the political declaration on future EU-UK negotiations does make clear that there will only be limited provision for the mobility of people in any subsequent agreement. Now, of course, what Theresa May calls an achievement is actually a victory for propaganda over evidence and rational self-interest. It's an achievement of sorts because it is one of the greatest triumphs for post-truth politics so far in Brexit Britain. Second point, even focusing on the legal regime that will govern the future protection of existing migrant citizens, we're going to talk primarily about the terms agreed under the proposed treaty, not the way in which that treaty then needs to be implemented into the 28 different legal systems in the UK and across the EU. Now, obviously, that national implementation is very important. It's true that most of the citizens' rights provisions in the proposed treaty are detailed and precise. They are intended to be directly enforceable on their own terms. But some of those provisions do allow individual countries to make important discretionary choices about how to treat existing migrant citizens, so that the overall treaty does need to be read within the context of each individual national system. Moreover, the treaty regime is expressly described as a minimum standard of protection only. Individual countries can go beyond its provisions and offer more generous rules. But obviously we don't have the time or frankly the expertise to examine 28 national implementing regimes, so although we make reference particularly to the UK system, we're going to focus on the proposed withdrawal agreement itself. Thirdly, and on a similar note, we're going to offer a general overview and a critical assessment of the citizens' rights provisions in the withdrawal treaty because we want to inform our viewers about the key issues, but there's a lot of detail that we won't be able to cover. Remember that any immigration system works by dividing effectively the entire population of humanity into categories. Each category then carries a different set of rights and privileges, of obligations and restrictions. You have own nationals, resident foreign workers, non-resident foreign workers, students, work seekers, the retired, close family members, distant family members, and it's not always easy to work out exactly which category you belong to and which precise bundle of rights will flow from it. But like it or not, everybody potentially affected by Brexit has to figure out for themselves which new category they'll be assigned to, which new rights they can expect, and which steps they have to take in order to protect their own interests. There are various user-friendly guides available online, for example, but in the case of doubt, you should, of course, consult an appropriately qualified advisor. Enough provisos. Let's then focus on the citizens' rights regime, which is to be found in Part 2 of the proposed withdrawal treaty. Now, the basic idea is pretty straightforward. Those EU or UK nationals who've already lawfully exercised their right to reside in their host country under EU rules on the relevant cut-off date will be offered a new system to protect their subsequent residency and associated rights into the future. Now, if they've already built up at least 5 years of lawful residency, they'll qualify for long-term protection, and if not, they'll be offered interim protection in accordance with the same EU rules until they reach that 5-year mark, and then they can qualify for the long-term protection again. Now that's the basic idea. Let's break down that idea into some of its key elements, and I'll focus on 4. First up, what is the relevant cut-off date? After all, this date is absolutely crucial. People who move before that date will continue to do so under existing EU free movement rules and are then potentially protected into the future under the proposed treaty. But almost everyone who moves after that cut-off date will do so under and subject to the ordinary immigration rules of the UK and the EU27. Now, at the EU's insistence, the relevant cut-off date will be not the date of UK withdrawal from the EU in March 2019, but instead the end of the transitional period. So that means the 31st of December 2020, or later if the transitional period is eventually extended using the facility which is now provided for under the treaty. So that gives everyone at least 2 years, possibly 3, maybe even 4, to build up more time, either to secure their long-term protection immediately upon the eventual expiry of transition, or indeed to move country altogether and start building up their 5 years of lawful residency from scratch. The second key element of the regime is that it relies on existing EU free movement law as its general baseline, both when it comes to identifying who is entitled to protection and as regards the actual content of their associated rights. As such, the new regime incorporates not just the benefits and advantages, but also some of the problems which we associate with EU free movement law. Now, forget the Leave and indeed the government propaganda about unlimited free movement rights. There is no such thing. Until someone acquires permanent residency, free movement rights are basically limited either to the economically active, people in work or in self-employment, or the financially independent, people who have enough money to look after themselves and their family, and, crucially, who are covered by comprehensive sickness insurance within their host country. Now, there are a few exceptions, of course. For example, there are more generous rights for people who are forced out of work through an industrial accident. There are less generous rights for work seekers who are genuinely trying to find a job, but there's certainly no right simply to go and live in another country at its public expense. Now, to qualify for protection under the withdrawal agreement, migrant citizens have to be lawfully resident in their host country in accordance with those EU rules, both at the end of the transitional period, but also during that crucial 5 years of time when they're building up their entitlement for long-term protection. And that's potentially problematic for people whose residency hasn't been strictly in line with EU free movement rules. For example, if you've had a career break to raise children or to undertake other care responsibilities, and you didn't take out sickness insurance for that period of non-work. And as Professor O'Brien in York has pointed out, these requirements can have a particular impact upon women. Perhaps the most important complicating factor, though, is that many member states, including the UK, simply haven't enforced the EU free movement regime very rigorously in the past. They haven't insisted that people who arrive meet the various criteria for residency, or they haven't pursued situations of non-compliance. And that potentially leads to problems if and when the real rules are enforced more rigorously against migrant citizens under this withdrawal treaty. For example, if a country now insists upon evidence of sickness insurance for all periods of non-work. Now, if any given country does decide to start enforcing the EU free movement rules more strictly, then some people who believe themselves to be lawfully resident, in fact who may well have been encouraged in that belief by their host country, may well find that their application for protection under this withdrawal agreement is more complicated than expected. Now, some people, for example those who've been resident for a very long period of time within their host society, will be able to benefit from some protection under the separate regime of the European Convention on Human Rights, but that won't benefit everybody. Nevertheless, as we said before, the withdrawal regime is a minimum standard only. A country can decide not to enforce the EU baseline strictly and to the letter, and on this point the UK does actually provide a good example. The government has said that it will operate a more straightforward system for EU citizens living in the UK at the end of the transitional period, based primarily on evidence of residence and without, for example, having to prove comprehensive sickness insurance for students or the retired. Now, the third key element of the new regime concerns those situations where it deviates from the general baseline which is provided by current EU free movement law. Now, to be fair, there are a couple of instances where the proposed regime allows for a higher standard of protection than would normally be the case under EU law alone. Take Irish citizens. The proposed treaty explicitly recognises that the UK and Ireland can continue providing for special treatment for each other's nationals under their respective immigration regimes. Now, that special treatment isn't just the result of some deep brotherly love, it's actually a straightforward consequence of the fact that there's no easy way to distinguish between Irish nationals from the Republic as opposed to those people born in Northern Ireland who exercise their right to claim Irish citizenship as guaranteed under the Good Friday Agreement. So, brotherly love or not, the UK simply has no choice but to treat all Irish nationals on a more or less equal legal footing with British nationals. Which means that Irish nationals in the UK aren't obliged to seek protection under the withdrawal agreement, though they still need to figure out how far they should nevertheless still engage with the new regime. For example, if they have any family members who aren't themselves British or Irish nationals and may need to register for protection in their own right. In a range of other situations, however, the proposed regime allows for restrictions on future citizens' rights protection which wouldn't comply with existing EU law. For example, countries are entitled to insist that migrant citizens go through a formal application process in order to qualify for future protection, failing which they may end up simply losing their rights altogether. And that is what the UK has done with its proposed settled status scheme. Or another example, the range of family members who would be entitled to join a migrant citizen in their host state after the transitional period has expired is more limited than the current definition under EU law. Moreover, there are several situations where the loss of existing EU rights simply hasn't been addressed in the proposed treaty at all. For example, there's no provision on continued rights to vote in local elections. The EU has simply treated this as a matter of national competence for each individual country to decide. There's no provision for the recognition of future professional qualifications, even for those migrant citizens who are protected under the withdrawal agreement. That will simply be left to future negotiations between the EU and the UK. And probably the most important, there's no provision for the onward movement of UK nationals outside their host country and across the wider EU. The problem of the so-called golden cage. Again, this is going to be dealt with, if at all, under future relationship negotiations, though in the meantime, at least some UK citizens may be able to rely on the existing EU rules which govern the internal migration of third country nationals. For example, allowing long-term resident foreigners to exercise onward movement rights which are based upon, even if not quite identical to, those enjoyed by Union citizens themselves. So, we have an EU law baseline. It's subject to certain additional restrictions, though there is always the possibility of more favourable treatment in an individual country. But of course there's another important underlying point to all of that. Because after Brexit, the entire basis for and context of EU-UK migration is going to change profoundly. And that will be for everybody, of course, but it certainly isn't exempt for those existing migrant citizens protected under this agreement. Things which weren't such a problem before risk becoming much more serious problems into the future, especially because, as Professor Spaventa from Milan has pointed out in her work for the European Parliament, whereas a change in or a loss of status under EU law is relatively flexible and only ever temporary, a change in or a loss of status under this citizens' rights regime is potentially terminal and permanent. Now, the fourth and final key element of the new regime concerns its interpretation and enforcement. Now here, the general provisions on governance of the withdrawal treaty as a whole will also apply to the citizens' rights provisions, the role of the Joint Committee and international dispute settlement and so on. But far more important in practice is the system for how individual citizens will be able to interpret and enforce their own rights before the courts of the UK and the EU27. Now in that regard, the proposed treaty sets out a fairly comprehensive regime. There are rules about consistent interpretation of the citizens' rights provisions, including the legal status of relevant ECJ case law, a time-limited power for UK courts to seek binding interpretive guidance from the Court of Justice. There are also provisions about legal enforcement by individuals. Their rights, for example, will still be governed by the familiar EU principles of direct effect and supremacy, even within the UK as well as across the EU27. There are extra provisions on monitoring and compliance, including, for example, a new independent authority within the UK. And in fact, most of the concerns relating to implementation and enforcement of the citizens' rights regime are more empirical and practical rather than formal and legal. To take the UK as an example, the sheer number of people involved, combined with the novelty of the situation, makes it seem inevitable that some things will go wrong. There will be large numbers of people who have only a very limited engagement with national immigration systems, or might simply assume that they're not covered or affected by this new regime. Will the government's publicity be sufficient? And what should the authorities do if significant numbers of EU citizens simply don't engage with the new system? Will they deport them all? There are concerns about ensuring that the UK's compulsory registration system is genuinely simple and user-friendly, especially for people with limited technological skills or aptitudes. And of course, there are worries about the clarity of the criteria which can be used in no situations where the immigration authorities have a discretion to reject applications or revoke protections. But another group of issues relate less to the potential abuse of power by public authorities and more to the intersection between this citizens' rights regime and private sector behaviour. What will be the impact of all of this uncertainty, of this complex new regime, upon the treatment of EU or UK citizens by private employers, private landlords, private service providers? And in the UK at least, those concerns are exasperated by the government's decision not to issue protected EU citizens with a new document. They propose to rely instead upon a digital reference number that private sector employers and landlords can seek to verify online, which of course sounds entirely foolproof. And finally, there are questions about various future decisions which remain to be taken about citizens' rights under the proposed withdrawal treaty. For example, there's the possibility that the UK might decide not to keep track with certain future changes to the EU rules on cross-border security benefits for migrant citizens. There's also the possibility that the UK might eventually abolish the independent authority responsible for monitoring its own compliance with its ongoing international obligations. But under the proposed treaty, those are decisions to be taken by the Joint Committee, requiring mutual agreement between the UK and the EU. But how will those decisions be treated under UK law itself? Will they be subject to some form of ex-ante parliamentary scrutiny and control, or will they be designed simply as executive decisions to be taken by the government, which Parliament then has to live with and implement into domestic law? Let's wrap up. As we said at the outset, there's a lot more that could be said about the detail of the proposed regime. There are special categories of individuals that are treated in particular ways, such as frontier workers. There are complex provisions on cross-border social security that will determine precisely how Brexit impacts upon, say, pensions or healthcare benefits. And we've not even mentioned the position of EFTA nationals from countries such as Switzerland or Norway. But what does the overall picture tell us? As we said in our recent video about the draft withdrawal package as a whole, there's a real risk that Brexit is such a dog's dinner that anything which isn't a complete disaster is somehow presented as a form of success. And what's true of Brexit in general is true also of the citizens' rights provisions in particular. Now, we could say that the citizens' rights deal is generally satisfactory. We could hope that individual countries err on the side of generosity in their national implementation plans. We can keep our fingers crossed that most people's experience of registration and protection proves essentially smooth and straightforward. We can cynically assume that many of the deal's shortcomings will only have limited negative impacts upon relatively small numbers of people. Fingers crossed. But is that really good enough? Now, anyone who believes that Brexit is all about abstract ideas like sovereignty or regulatory alignment should really take a few minutes of time to speak to one of the people, the actual people, whose lives were turned upside down on the 23rd of June 2016. Because even if Brexit gave no other cause for concern, even if it created no other grounds for complaint, the very fact that millions of people, both in this country and across the rest of Europe, have seen their lives and their futures thrown into a state of uncertainty and anxiety is an unforgivable act of cruelty. And it's not just uncertainty and anxiety. Let's not forget the bigger picture here. For years, EU nationals have had to listen to themselves and their families being demonised and scapegoated by the Leave campaign. Since the referendum, this anti-European, anti-immigrant rhetoric has been directly endorsed and adopted by the government as official UK state policy. Although we now know, of course, that this was merely a continuation of the hostile environment policy towards migrants as a whole, which was exemplified by the Windrush affair and presided over by Theresa May. The same Theresa May, it's worth recalling, whose Home Office was accused of doctoring the evidence during the coalition government's balance of competence review into the relationship between the UK and the EU, so as to try to paint migrant EU citizens in the most negative light possible. Should anyone be surprised that this political venom, this official animosity, sits alongside a reported rise in hate crimes as well as discrimination against EU nationals in fields such as employment or housing or service provision? Is it any wonder that growing numbers of generally better educated, hard-working, tax-paying EU citizens are now shunning the UK with potential damage not only to the private sector but also to public services such as the health service or education? Or is the real surprise that so many Leave campaigners, whether within or outside the government, aren't ashamed of the way that they've dealt with this entire situation? Two short final points. First, I'm often asked, how should people affected by this change react? Should they, for example, boycott the UK settled status regime? Should they just ignore it and carry on as before? Now, I can understand the feeling for many people that working with this system feels like an act of humiliation, even of collaboration. But regardless of the bigger picture, the only responsible advice surely is that you need to protect your own interests and those of your family. You need to know which category you're going to be allocated to. You need to know the implications that will have for your rights and your obligations. You need to know the processes that you're expected to follow. Because the bottom line is, do you trust this government to look after your interests? Secondly, what happens if the proposed withdrawal package is rejected by Parliament and the UK looks set to continue to leave the EU in March 2019, even without a deal? Now, within the UK, there have been long-standing calls for the government to offer a unilateral guarantee to existing EU 27 citizens, but it was only at the Conservative Party conference in October 2018, just over a month ago, that any sort of unilateral guarantee was eventually offered, though we still don't know precisely on what terms it might be provided should the need eventually materialise. Now, we can imagine that, faced with a no-deal Brexit, there'll be so many headless chickens coming home to roost all at the same time that there simply won't be enough time or resource to do anything other than implement the arrangements which have already been agreed under this proposed treaty. Probably not only within the UK, but also that would apply across the EU 27. So although there are no guarantees, it feels like a fair assumption that Part 2 of the proposed withdrawal treaty is what we're going to have to work and live with, even in a no-deal situation. Thanks very much for your attention, and we'll see you again soon.